Good morning and welcome to Love Me Tender, Considerations in Determining Whether to Accept Coverage. I'm Judy Ambrosio and I'm with Old Republic Insurance Company located in our Saddlebrook, New Jersey office. I will be your moderator for this webinar. For those of you who do not know me, I am in claims and I have over 30 years of experience. We'd like to say welcome. This is Old Republic Risk Management's first webinar, and while we are hoping that there will not be any technical issues, if there are, just please be patient with us. It's been a long week in preparing for this on the technical side. At this time, I would like to introduce our presenters. With us today is Steve Cherry and John Gorin. They are partners with the law firm of Mintzer, Sarowitz, Zeres, Ladiva and Myers, and they are a regional insurance defense firm. Steve is out of the Philadelphia office, and he has been practicing law since 1994. And John is in the Miami office, and he has been litigating for over 20 years. Also with us today is Renee Klum. She is a claim manager with Old Republic Risk Management. She is in the Brookfield, Wisconsin office, and Renee has over 30 years of claims experience. Just a few things before we begin. Attendees will remain on mute during the session. There will be a Q&A at the end. However, you can type questions in at any time during the broadcast. There will be a very short survey at the end. It is greatly appreciated if you would just take a few moments to complete it. And if you have additional comments, you could also email gotowebinar@orrm.com. This session is being recorded, and we anticipate it being on Old Republic Risk Management's website within a week of the broadcast. All parties have consented that the slides that are being shown today can be released to any attendee if they want a copy. If you are interested, please email gotowebinar@orrm.com. At this time, I just want to read a very short disclaimer before turning it over to our presenters. The remarks and materials are not intended to provide legal advice, but are rather provided for informational purposes only. Should you require legal advice, please seek advice from counsel of your choosing. The views expressed are those of the individual speaker and are not to be attributed to Old Republic Risk Management Incorporated or any of its affiliates. At this time, I would like to start the presentation.
Good morning, everybody. This is Steve Cherry.
Good morning. I'm John Gorin from Miami, Florida.
Well, everybody, thank you for attending, first of all. And we decided to call this presentation Love Me Tender because we know that everybody loves getting tender requests and dealing with them. Well, maybe not, but they are an important thing that everyone is going to have to deal with in their claims adjusting career. And we wanted to provide this topic to this presentation to give you an overview of the issues that you really should be considering when you have to address a tender claim. And I just want to start off by saying, well, first of all, we wanted to have some Elvis impersonators come in here and provide you some musical interlude with Love Me Tender, but they haven't shown up yet, and everybody else thought it was a bad idea that I sing instead, so that won't be happening. So in any event, we wanted to proceed on and provide you with, again, an overview of the issues you really should be considering when addressing a tender claim. The most important thing when we start now is to know your jurisdiction. Tender claims are going to be brought regarding policies and claims that are around the country, and really while there is, and what we're going to talk about today is sort of a general overview, and there's going to be drastic differences amongst the jurisdictions, but even though there is some common threads, we can't urge you enough to make sure that you know what jurisdiction you're dealing with and the particular rules in that jurisdiction. But in any event, moving on, as a general overview, we wanted to give you an idea as to the different thoughts and issues you have to deal with when addressing a tender claim. First of all, what is a tender claim? What is a tender? A tender is when some entity that is not your name insured is asking your insurance company or the insured itself to defend and indemnify them with regard to a claim or a lawsuit. And usually an attorney or the third party themselves will come to you and say, we believe that you should be defending and indemnifying this third party, us, with regard to this particular lawsuit. And you have to respond to that appropriately. So to do that, you have to consider basically two different sources of a duty to indemnify or defend some other third party. And we've put these down into four general areas in this slide. And the source of such a duty can be either policy-based or contractual-based. So we're going to proceed in discussing with you the different types of the sources of this duty based on these basically four different types of areas. First, the first two are policy-based. Is this third party a named insured? Are they a certificate holder? If they are a certificate holder, what does that mean? Secondly, is there a blanket provision endorsement in the insurance contract, in the policy, which would provide insurance coverage duties to this third party? Those are the two policy-based ones. Also, there are contract-based sources of a duty, which you have to consider as well. Is there a contract provision requiring that your named insured add this third party as additional insured? Or is there a contractual provision requiring in the contract your insured to indemnify and defend this other third party? So first we're going to talk about the policy-based duties.
Now, just to dovetail, this is John Gorin speaking from Miami. Just to dovetail on what Steve said, we know many of you have different backgrounds. Some of the claims that you might be dealing with are tort-based and some are contract-based. In either event, there's an aggrieved party that is seeking coverage under the policy, and we've tried to steer our comments in that direction. And in addition to the slide that's on your screen right now and the one that you saw previously, a significant consideration is at what stage is the tender in? In other words, has a lawsuit been filed, or is this in a pre-suit stage? And that's significant because you do deal with jurisdictions that have, I like to refer to it as a four-letter word, but it's really not, bad faith considerations. Sometimes the time is on the clock for you to acknowledge a demand from an opposing person that's seeking coverage, and then you've got other coverage carriers that need to be put on notice. So first of all, when is the at what stage of the proceedings are you at? Very important. Are all carriers involved? Has everyone been put on notice of this? And sometimes, as I mentioned before, kind of alluding to the bad faith consideration, are you dealing with a time-sensitive demand? Now, Steve and I are going to get into the fact that, as he's mentioned, sometimes it's policy-driven, sometimes these matters are statutorily driven, and yes, sometimes you have to get the courts involved. There's also, if you're dealing with that situation, there can be circumstances when you have an insured that has a contract that requires that they indemnify somebody. In another paragraph in that same contract, you might have an option or even a requirement that such disputes be subject to arbitration. All of these things have to be taken into consideration in addition to, as Steve mentioned, talking about what venue are you in. Sometimes it might be to your advantage to consider an arbitration situation because, let's just say, if you have a lack of confidence in your judiciary, sometimes it might not be bad to have a panel of arbitrators take these things into consideration.
So in any event, these are things you should be thinking of first. Make sure you obtain every applicable policy, particularly your own insurance policy and your policy, and also look at what particular contracts that may be applicable to your insured and this third party that's seeking coverage. So taking a look first at the policy-based duties, like I said, you want to look at your policy. You want to look at what sources are there in the policy which could give rise to a duty to this other third party. You want to look at what are some of the things you want to look at? Well, you want to look at the definitions in the policy. You want to look at whether this third party which is seeking coverage is a named insured, whether they're an additional insured, or whether they're a certificate holder. And we'll talk about right now what each of those mean. And the source that you find this information is basically the policy and the certificate of insurance. Like I said on the slide, you'll see you look at the definitions. Where do you find this information? And once you find it, you have to determine whether or not, if this other party is an additional insured or a certificate holder, what rights they have under your policy in comparison to the named insured. So first, what is a named insured?
Yeah. Sometimes that's a very easy question to answer. Sometimes it's not so easy to answer. The thing to keep into consideration is when you're looking at the persons, the individuals, the entities, whatever you're dealing with that are involved, generally the named insured, as you'll see in the last sentence of our slide, is the entity which originally sought and paid for coverage. Now, ultimately, when we talk later about additional insureds, they'll have some of the same rights under the policy that the named insured has, but ultimately it's that named insured that has the most powerful of all benefits to the policy, and that they have excuse me, too much caffeine this morning. They have the right to terminate the contract. Now, one thing to go back to what Steve said, when you're looking at these different definitions, it might sound basic, it might sound simple, but make sure you have a current copy of a given contract that is going to, and by contract I mean policy, that is going to apply to the incident in question. Endorsements change, additional insureds change. Generally, the named insured is not going to change, but year to year, these things change, and they need to be looked at before litigation starts, before the nasty letter writing starts, those kind of things. Make sure you know who the named insured is and who these other entities that Steve and I are going to talk about are. Now, when you get the additional insured, for those of you, and I know we have over 100 here that are in attendance that have different backgrounds and different insurance-related needs, the larger entities that are out there in the world that have insurance coverage oftentimes have what Steve and I like to refer to as long-standing relationships with their named insured. So when you're considering this tender acceptance, you want to sit down as the attorney, and again, as Judy told you in the beginning, we're not going to give you advice, but one of the things you should consider is understanding the relationship between that insured and that additional insured. You want to understand it. You want to know the nature of it. Many, many times, there's a long-standing relationship that, as the attorney, you don't want to step on. And there are actually so many things to consider in whether or not to accept a tender, but in addition to keeping everybody apprised, keep the lines of communication open, because there are many things, many issues, many circumstances, and even I can go so far as to say times when litigation can be avoided if people just pick up the phone. In other words, that big entity that has your policy, sometimes they know someone that they go back 10, 15 years, and it's, we've got this issue, somebody wants this policy money, and how are we going to do this? And I use the term unified front, but at least shoot for that unified front if you can. Sometimes you can't, but it's better for the plaintiff lawyers in a tort claim when insurance companies and individuals are fighting over coverage.
So an additional insured is not your named insured, but it's some other entity which the policy says has a duty, or has an obligation, or rather has a right that your company has a duty to provide insurance coverage for as well, even though they are not the named insured. What is a certificate holder? A certificate holder is an entity which has or holds a certificate of insurance evidencing your policy. And I'm sure all of you have seen certificates of insurance before, and you deal with them all the time. Essentially what they are, it's a document which is usually prepared by a broker or some third party which states that this insurance policy exists and it's evidence of a policy. Sometimes it says on the policy, so-and-so is an additional insured under this policy. Or it may say some other description of an additional insured or some other party, or indicate perhaps some rights under the policy in the remarks section of the certificate. However, as we'll discuss further, just because there is a certificate and it may say something on the certificate does not necessarily give that party any rights under the policy. It is usually the policy that controls. And depending on the state, they have different rules as to whether the certificate being issued by a broker or an agent gives any additional rights as a result of the certificate. And I think Renee may have a comment to say about that.
Yes, thank you. This is Renee Klum. Oftentimes our customers do need to show proof of insurance, and Old Republic does not issue those certificates. The insured's broker issues those certificates on behalf of our insureds. And those certificates do not alter our policy. Our policy is altered only by endorsement. Now, Old Republic does regularly endorse the policies in response to the insured's broker's requests when they have the need to conform to the requirements of a particular certificate holder. So again, it's the policy that conveys coverage and any changes. And when you have specific questions along those lines, those should be referred to your service team, and they're always ready to assist you with those. Thank you.
And as Renee said, there are, as she suggested, that there's lots of, this issue comes up often, and there's lots of litigation, as we've indicated here in this slide, in which certificate holders who, even though it may say something on a certificate of insurance about them perhaps being an additional insured, it doesn't say it in the policy, and that usually winds up in turning into litigation. And as Renee said, it's generally the situation that if it's issued by a broker, it's not considered to be the changing to the policy or inuring to the intent of the insurance company. So, how do you find information regarding who an insured or an additional insured is? As I said before, these are policy-based duties. So initially you must look at the policy. In particular, several portions of the policy. First, you want to look, obviously, at the declaration page. This is, you are all very familiar with what a policy looks like and the different parts of it. Declaration page, obviously, is generally at the beginning of the policy, which sets forth a general summary of the type of coverage the policy gives. It indicates who the named insured is, indicates the limits of liability coverage, indicates oftentimes premiums that are paid, but sometimes not, and often also indicates what particular number endorsements are made part of the policy. Oftentimes, this declaration page may also specifically indicate who additional insureds are, so you obviously want to look at there first. Also, the policy, all policies have definition sections, and most of them, especially ISO policies, do have a section in the definition section, who is an insured. And that will set forth certain parameters of who is automatically deemed to be an insured under the policy. And you have to look at this definition section, this who is an insured section, initially to see if the party seeking coverage fits within any of those parameters. Also, a lot of times a policy will also have separate endorsements at the end of the policy, which will indicate that either a particular entity or a category of entities are considered to be additional insured under the policy. Now, a particular category of entities as part of an endorsement, that's considered to be a blanket additional insured endorsement. And oftentimes this will be in types of policies, liability policies that will say, for example, a certain class, anyone that you lease premises from, who owns the building. any type of entity that you're performing work for, construction work for, under a written contract. Any type of class of other entities described by category rather than an individual name. So you have to look at those. Again, look at all the endorsements of the policy. Oftentimes there are many endorsements of the policy, and even though some may not have a title on the top of them that say additional insured endorsement, you still ought to make sure you're familiar with all the endorsements of the policy to make sure that there isn't something that's snuck in there under a different title or no title at all. It's the wording of the endorsements that control, not the title.
Now, you take all this information, as we're speaking from the vantage point of the attorney, but you as the claims handler or the self-insured, you take all this information together and you're determining who the insured is, who the additional insured is. Steve and I sit in the vantage point of we're trial attorneys. We defend people that are being sued in commercial and tort settings. Now, there are a special breed of attorneys that are coverage attorneys that often do nothing but make determinations across all 50 states as to who, and in fact internationally, who an insured or an additional insured is. Now, this is an important thing to keep in mind. It's the defense attorney, it's the claims handler, it's the coverage attorney. But I'll go back to that point about remembering relationships. You know, if you're attending a seminar with an attorney, you know you're going to hear a war story. In 2007, I defended Miami-Dade County in a catastrophic tort claim that the question arose as to who additional insureds were, what type of coverage there was, and whether or not it was a construction accident or a maintenance issue. And I go back to that point that I made with respect to developing relationships. Before everybody started gearing up, pointing their cannons at each other and firing off cross claims and getting nasty to litigation, one of the things from working with each other and speaking to each other that we realized was that the injured individual, under a statutory employment scenario in the state of Florida, was an employee of all of these entities, and therefore there was workers' compensation immunity. Hundreds of thousands of dollars in legal fees could have been spent, relationships could have been burned. In that case, I know that's a remote one, but there are circumstances where one of the parties, the insured, the additional insured, may have a defense available that may be to the benefit of all.
So just finishing up with this slide, other areas that you may need to look at to determine whether somebody is an additional insured under the policy is you may also need to look at the records that are on file with the insured's office, because oftentimes the policy will have an endorsement that say, particularly a blanket endorsement will say that additional insureds are as on file with the company. So you have to look at that as well. And lastly, oftentimes the contract, if there is a contract between your insured and the proposed additional insured, may indicate that someone is to be added as an additional insured. And we'll talk about these contractually based duties. But then again, when we talk about this later, we'll make clear that just because there's a contract itself does not necessarily give that entity, that third-party entity, additional insured status. It's the policy that controls. Further in that regard, the question often arises, and John alluded to this a little bit earlier, that sometimes someone will take the position that, or consider whether a additional insured has different rights or status under the policy than your named insured. You may get a tender request from a third-party additional insured who's named as who is identified in the policy as an additional insured, and you might tend to think, well, they're not our named insured, so we don't have the same duties or the same level of coverage under the policy. That's a dangerous position to take. Most jurisdictions, and I can tell you certainly for Pennsylvania, will hold that an additional insured has the same rights as a named insured under the policy unless the policy says otherwise. And many insurance companies and many policies are written that do attempt to have some limiting language in the additional insured endorsements, limiting the coverage owed to additional insureds to be slightly different or less than the additional insured. However, it's the policy that controls. Don't automatically think because someone is an additional insured that they don't have the same level of coverage or you don't have the same duties owed to them. And again, this is further detailed in this slide here as well.
And these are things, just to finish up on what Steve was saying, no one should think about or consider these issues. I'm sure Steve agrees with me, and I know Judy does. Don't try and think of these issues in a vacuum. These are matters to be roundtabled, discussed with counsel, and really thought about before decisions are made, because the implications can be long-term and can get expensive.
So, as we said, it is the policy language that always controls, and it's something that you really ought to look at and read the policy language carefully. It's the language of the endorsements that matter. It may be mumbo-jumbo, but it's important mumbo-jumbo, and it's the mumbo-jumbo that controls. So make sure you read it and you understand it fully. Now, for example, there are issues that are determined by particular language. And this is why the language is important, that you that you understand it. Particularly with regard to additional insured endorsements, a lot of them, like I said before, do attempt to limit the duty owed to additional insureds to be somewhat less than named insureds. For example, there are often additional insured endorsements that say we're going to provide coverage only with respect to liability arising out of the primary insured's work or operations. This language, I can tell you, results in a lot of litigation around the country and raises all kinds of questions as to what does that mean, only with respect to liability arising out of the primary insured's work or operations.
In some of the language that you're going to see that we're coming up on, the tighter the language can be, as narrow as it can be, the more a court is inclined to interpret it in a way that favors coverage. These big, broad language that you'll see up ahead in the next point that's on your slide, generally courts tend to struggle with those.
And I could tell you in Pennsylvania there's always an argument as to whether there's the endorsement says claims as a result of the operations of the primary insured, or claims caused or injury caused by the work of the primary insured, or arising out of. And I can tell you in Pennsylvania there's a primary case, the ERSIT case, which stands for the proposition that when it says arising out of work, that's basically what they consider but-for causation, meaning that even though it may not come from the work itself or be integrally related to the work, as long as but for the work being performed at that location, that's considered to be within the realm of coverage. For example, your primary named insured may be working at a certain section of a building, and the workers, for example, are walking through another section of the building to get to where they're supposed to be working, and they trip over a pipe, or they trip over a hole, or some injury occurs while they're going to where they're supposed to be working. Well, technically, even though they weren't working at that location, you can make the argument, well, it's not really their work. The Pennsylvania courts, using that but-for causation standard, has said, well, the reason they were in that section of the building and the reason the accident occurred was because they were heading towards their work. And if it wasn't for the fact that they were working elsewhere in the building, the injury wouldn't have occurred. So therefore, we're considering as part of that arising out of standards in the additional insured endorsement.
And as you can see from the slide on your screen, what happens when the named insured is a party to a contract and he agrees to name, he or she or that entity agrees to name someone as a named insured, but it doesn't, is the insurance carrier bound by the contract between the two parties? Generally, I don't think Steve and I can waffle on this one from jurisdiction to jurisdiction. The insurance carrier is not liable, but the insured is liable to the other party as if they were an insurer. And as you can see, we put some cases up there. There's a Florida case up there and a couple of Pennsylvania cases. That's a problem for the insured.
And that's also something to consider, and we'll mention this later also, that even though that isn't a coverage aspect for the carrier, the fact that the insured is now facing, your primary insured is now facing a breach of contract claim by the third party, which was never added by the insured as an additional insured on its policy, that may give rise to a duty on the insurer to defend and indemnify your primary named insured on that breach of contract claim, because it may be considered to be an insured contract under your policy. So even though there technically is not a duty for the insurance company to defend and indemnify the proposed additional insured, if the insured, the primary insured, never named them as they promised to as an additional insured in their policy, it may come back around to the insurance company in the form of having to defend your primary insured in a breach of contract claim.
And there was, just to finish up on that last slide that was up there before, you don't have to go back to it, that type of thing was not deemed to be an occurrence under the definition of a policy in some case law that we found such that there was a duty to provide coverage. Another consideration, again, just a small example of the differences between the jurisdictions. I know in some of the construction cases that I've litigated, this Florida statute, section 725.06, requires that there be monetary limitations, or what we lawyers like to refer to as liquidated damages, and towards the extent of the indemnification, such that it's not something that goes on in perpetuity. I don't know, Steve, is there anything like that in Pennsylvania?
There's nothing like, no statutory provision like that in Pennsylvania, but there are in other, well, there's a general trend by way of case law in Pennsylvania that indemnification provisions are construed strictly, and so we'll talk about this more in a couple of slides, that unless the contractual provision specifically indicates that it's going to cover a third party for their own negligence, that it's not going to be enforced that way. But there's no statutory provision limiting it per se in Pennsylvania. A few other states do have similar statutes. I know New York has a statute like that. You know, Minnesota has a statute like that, particular to construction contracts. But again, this is a reason why you really need to be familiar with the jurisdiction that you're dealing with and know what jurisdiction you're dealing with in answering any kind of tender-related question. Okay. Is there any exposure to a carrier when an insured fails to obtain additional insured status for an entity under his contract? Well, this is what we just mentioned, where there is not a direct duty on the part of the carrier to provide defense or indemnity to this third party seeking coverage, where the primary insured didn't live up to its promise to have them named as an additional insured on their policy. There is potential exposure, though, indirectly, insofar as the carrier may be required to defend and indemnify as an insured contract any breach of contract claims that the third party may have against your primary named insured. So, that being the case, when you're provided with a tender request by a third party, and it's pretty clear that they're not a named insured under your policy, but it's also clear that your insured under their contract was supposed to name them as additional insured under your policy, but they didn't, you might want to consider whether it would be most cost-effective or economical to voluntarily assume the defense and defend this third party to avoid the pitfall of having to defend your own insureds under a breach of contract claim, where the remedy for that third party would be as if they were actually provided insurance.
And this is another one of those circumstances. We see these kind of things happen, and letter writing can start, and nasty pleadings can be threatened, but keeping an eye on the end result. You know, as Steve just mentioned, the carrier can be in the situation where it's defending and potentially indemnifying for the insured's failure to designate this entity or person as an additional insured, when what is or what are the damages in the case? You know, this can be, you know, again, I hate to bring up another war story, but there are many times when if everybody sits down and looks at what is the cause of action, whether it's a commercial dispute, whether it's a construction dispute, whether it's a tort-related claim, sometimes the ability to spend hundreds of thousands of dollars litigating something when it could go away for a very small amount with no hurt feelings in the end, and everybody's the wiser and can move forward in the future and handle things a little bit differently in terms of clearing up who that additional insured is. Sometimes that's an option. It should be considered. It's just a suggestion.
Okay, and again, lastly, when we're talking about policy-based duties, you have to look at the language of the endorsement and look at it very carefully, make sure you understand what it says, and make sure that it does or does not fall into place with the nature of the claim or the nature of the coverage that the third party is asserting. Again, we talk about the endorsement when it talks about claims as happening as a result of your insured's operations or arising out of, and know your jurisdiction and know what the differences are.
And I know, Steve, I'm sure you're familiar. There's textbooks and there's treatises that do nothing but track policy language and how it holds up in and around the country. I know frequently I'm asked, you see language like you can see here on the screen, and the court held the words "as a result of" is the same as arising out of. There's actually legal sources that you can go to do research to see how specific language has held up in court challenges. And it's worth the time if you want to make that educated decision about whether or not to accept the tender.
And again, that's another example of why in some of these dicey situations, you certainly want to seek the advice of coverage counsel who will have a greater knowledge of how these words and terms are interpreted in a particular jurisdiction you're dealing with, so you can make an educated decision on whether to accept a tender. Now, moving on to the contractual-based duties. Those were what we talked about thus far have all been policy-based. You also have to look at the insured's contracts to determine whether the insured has a contractual basis to hold harmless and indemnify a third party. And you will be asked often to assume the defense of this third party seeking your insured to defend and indemnify them. You may be required, as your named insured's insurer, to defend and indemnify this third party under an insured contract. So we have to look at the contractual basis for indemnification.
And just to follow up on what Steve said, that's exactly where the court is going to go. If you find yourself in what we call a declaratory action, where there's a determination made by a court as to what is the coverage owed or who is the insured or the additional insured under the policy. And just to digress for a second, I know, Steve, in preparing for this, these things can blow up and go crazy. I'm sure you've been in a situation where you're defending something in Pennsylvania, and because of the forum or the jurisdiction where the insurance carriers are, they're all the way across the country, some federal court judge is being asked to determine the language in the contract. It gets time-consuming. It gets expensive. Something you want to avoid if you can.
And again, there's going to be probably in any type of big claim where there's a coverage issue, there's going to be the initial fight over what jurisdiction's laws to be applied, because each forum state has their own rules as to choice of law, particularly with regard to the construction of insurance policies. Some states say that it's where the law is to be applied where the contract was formed, meaning either the home residence of the insurance company or the home residence of the insured. Some states, such as New Jersey, talk about where the policy was delivered, and that turns into who provided the policy, whether it was sent to the home address of the insured or the broker issued the policy. You really have to be aware of what state jurisdiction you're dealing with and what state laws to be applied to the construction of the policy. But getting back to this contractual-based source of indemnification, the main issue that usually comes up with this thing is whether or not the particular contract that your insured signed requires them to defend and indemnify this third party in a situation where this third party either is guilty of its own negligence or is accused of being guilty of its own negligence. And that's where the fight usually turns into, and over these types of provisions. Like I said, and looking at the slides, a party may agree to indemnify another party for liability stemming from its own acts of negligence, and this is the situation in most jurisdictions. However, these are generally disfavored and strictly construed, and that's certainly the way it is in Pennsylvania, and I know that most other jurisdictions have different variations on that type of rule. just an example of what has been deemed to be sufficient language indemnifying a party for its own negligence and what isn't. See two different types, or the first type here, and these are examples of ones that have been determined by the case law in various jurisdictions.
And if you'll notice, the one on the top is a Pennsylvania one, and the one on the bottom is a Florida one. Just take a moment to look through the language there. I know we have just a few more minutes, but compare this slide to the next one that we're about to show you, where the language is and has been held up by courts as being sufficient. Compare it to this next one.
So generally, when there's language in the contract that says specifically, regardless of whether or not it is caused in part by party indemnified hereunder, that the courts will see that as being specific enough generally to allow for indemnification in cases of a third party's, the party seeking indemnification's own negligence. They've also seen when a contract says this will cause indemnification to all claims except those in which the indemnity is solely negligence. Cases have said that, well, when you're not solely negligent, if you're partly negligent, this is still going to cover it. So that's something you really ought to be familiar with. Read the particular contractual provision in question that the third party is seeking coverage under. Again, we talked about what happens when when the insured does not name the third party's as an additional insured, and also whether or not, if the contract itself does agree to indemnify others for their own act of negligence, does this mean that the insurance carrier is bound by the contractual indemnification agreement? Not necessarily, but again, if the third party then tries to assert a breach of contract action against your named insured, your company may be required to defend and indemnify your named insured on that breach of contract action. So again, it circles back to you indirectly. This is just further elaboration on that. Many CGL policies require that coverage be provided to its insured for assumed liability as an insured contract. Make sure you know the policy. Most importantly, whenever you have a situation with a tender request and you feel uncomfortable with it, it's not clear, do not be afraid to ask for the help of coverage counsel. These are complicated issues, and many states, as John mentioned earlier, have very strict provisions as to timeliness of when you have to respond to a tender request, and have other kinds of requirements that you owe duties on a particular timely basis to the proposed additional insured if they do turn out to be an additional insured. So therefore, it is important that you evaluate any tender request carefully, seek help if you need it, seek legal counsel, seek coverage counsel, but also, and this is something your coverage counsel will likely discuss with you if it's an issue, but you do also have to consider this on your own as well, which is whether if you do accept a tender and you do decide that you're going to appoint defense counsel to represent the additional insured or the co-defendant, is there a conflict of interest with the same defense counsel representing both? Do you need to have separate counsel? And that's going to be, that's a topic of a whole other discussion. However, just in generalized terms, based on our time restraints, certainly it's something you should consider.
Well, this is Judy Ambrosio again, and we really want to thank you for attending us for this first webinar, and we look forward to having you attend future webinars. Again, there is a short survey, and we would greatly appreciate it if you could stay on the line and fill it out. And if you require additional information, please go to GoToWebinar@orrm.com. Thank you very much, and this will end our broadcast.